Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon VanderLeek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome to another exciting episode of Estates Made Simple. Today we are joined by Michaela Summers, and I know Gord will provide a little bit more of a detailed introduction for Michaela, but we're really excited to have her today because together we are going to share stories from the trenches of what goes wrong when we don't plan properly and we don't administer estates properly. We find that most of the time the stories are the most interesting part. It's not the technical parts. It's what actually happened in real life scenarios. So we're really excited to share some today with you and hope the executors listening gather some lessons and encouragement along the way.
Yeah, and it's always nice to have guests. And this is obviously somebody from the office. Michaela and we've been working together, I think a sufficient period of time that it's hard for me to remember a time that we weren't working together, but articled with the firm. And we were delighted to call her back as an associate lawyer and has been here and I think gaining in experience, and we're working collaboratively on files. In fact, in terms of our practice, the head of our estate administration area. So she's the go-to person if we're trying to get an application through Surrogate Digital or have a question about the Estate Administration Act. So I think she comes from that perspective. Plus, also, it's probably helpful for me just to walk over to her office and say, "You're going to do this. You're going to participate on the podcast." So, thanks for your willingness, Michaela, to volunteer your valuable time when your boss says you need to be on our podcast.
I'm always keen to have Gord owe me a favor. So
there you go. I think there may be a few in the credit column to Michaela's advantage with regard to that. So, with the stories, as Jenna said, we're going to get into sort of some examples of stuff that we've experienced. And I remember working on this one case, Michaela, that not to give too much away, but let's just say trying to put this fact situation on intestacy, so somebody who died without a will, in a way that the judge reviewing the application would even begin to understand it, resulted in you doing a flowchart or organizational chart. So with that, maybe as teeing up the fact situation, tell us a little bit about that case, because I think it's an interesting story to kick off with.
Sure. And this is certainly a situation where even a little planning would have gone a long way. But this is a gentleman who didn't do a will at all. And of course, we end up with the government default and pursuant to the rules set out in the Wills and Succession Act, which for a lot of people is not necessarily a bad result, right? For, let's say, a young couple, one of them passes away and they don't have a will, while everything goes to the surviving spouse. That's not necessarily that different than what their will would say anyway. But for this person, he passed away. He had no spouse. He had no kids, no surviving parents, no surviving siblings, not even grandparents that were surviving. He had one surviving aunt and 27 surviving cousins. And so we ended up dividing the estate not evenly 28 ways. Of course, we have to follow the distribution. He has, for example, one uncle who had passed away and had 4 children, and another aunt who had passed away who had 2, and an uncle who passed away who had, I think, 7 or 8 children. So we end up with the estate being divided across all of the different aunts and uncles, and then further divided across all of these different cousins. And so to even begin to explain this to the court, we ended up putting together a diagram, which is, I think, the first and only time I've ever submitted a diagram as part of my grant application. But I just thought, I don't know how a judge is ever going to understand all of the different, this person's receiving a 1/36th of the estate, and this person's receiving a 48th, and here's how we're going to divide all of this up. And it really wasn't a huge estate either. We're only talking about maybe $70,000, or maybe even a little less than that by the time executor fees were paid and legal fees were paid. And we're maybe talking about $50,000 or $60,000, which I think if he had sat down to write a will, it probably, maybe he had a favorite cousin, maybe he had a friend that was important to him, or a couple charities that were important to him. and probably a couple of checks for maybe $25,000 each, divide between a couple of cousins or a couple of charities, probably would have gone a lot further than by the time we're writing all of these checks. A lot of them were for $400 or $500, some of them for $1,000 or $2,000, just really not significant amounts of money for any of the beneficiaries to receive from their distant cousin. And even just tracking down all those beneficiaries was a challenge. A lot of them didn't live in Canada. There were a few in the US, in Mexico, in Australia. So the administrative burden, I'm sure my assistant would be happy to talk about just all the time that she had to spend, even just that's a lot of envelopes when you're serving the application to 28 people, when you're trying to get releases from 28 people. It's sending out checks to 28 people. I'm sure we ate up a lot of photocopy and postage costs as well. Just the sheer administrative burden of divide estate 28 different directions. Whereas I think if he had sat down and even put a fairly simple will together, it probably wasn't the result that he would have chosen had he chosen for himself. But
I think that's a really good point, because you could say the law presumes the intent, right? Saying if you die without a will, this is the distribution, and you just follow the chart. And I think we've seen that a lot in the practice. This is a good example of saying, I think it's a fairly compelling argument to say, if he's across the table from us and we ask the question, what would you like in your will? How would you like your $70,000 to be distributed? He probably wouldn't have said what the result was in law. I think that's a pretty good chance. That's a fair statement. And so then you're left with, this is what happens. Is that really what he wanted? And just didn't make that effort to make his wishes be known. But I do remember that file because I think that was still in the pre-SDS, so the surrogate digital process. I don't know what the exact amount, but like you say, it all went out by registered mail and just contacted people. Certainly the legal costs, the amount of administrative time to be able to do all that was significantly enhanced. It could have been more money to the beneficiaries, less legal costs, had he just come up with a simple plan. But we have no choice. It's not like you can ignore, let's just make it 8, not 28. The law doesn't allow that. You have to give to the 28. It's a little bit simpler now with the new SDS process. It could go out by email, but even just plugging in 28 names, you got to verify their email addresses. It's just the number of beneficiaries was amazing on this one. And the chart, I think you had to put it in landscape mode just to make it fit, just to give a visual on this podcast of there's a lot of people, a lot of relationships, and people connected to who and deceased people, and quite an interesting flow. We got it done, but a heck of a lot more work as a result, right?
yeah, certainly. And you're right. It was pre-SDS days, so it would be a little bit easier to do now. But even getting email addresses for all of those different people, I'm not sure that we would have been able to. I think we still probably would have been sending out registered mail since some of the cousins weren't particularly well known to each other either. So.
Did you have to hire a private investigator to find any of the beneficiaries?
We didn't. We relied pretty heavily on, again, one of the cousins knows another one who lives in somewhere in the States, and he might have contact information for some of the other ones that are in Australia or Mexico or wherever, because they were just scattered. So we were able to get at least mailing addresses for everyone. So that worked out, but certainly a lot more hassle than it probably could have been.
I think the other thing to add, and Jenna, you and I have talked about this in the past, if you have some additional complexity, I mentioned the costs, right? We're sensitive to trying to do things as efficiently as possible, but it's okay. Quite a bit of work involved in all this, but also a delay, right? There's a time delay in terms of if you have that level of complexity, that's an estate gone badly, right? Where it takes a lot longer to administer because there's just that much more work. That has a direct impact compared to the alternative of, he would have just picked a few or done something simpler, then the money would have got to them in all likelihood a little bit quicker than maybe it did. So that's something to bear in mind too, is the speed at which the executor, or in this case, the administrator, would have taken to wrap things up, right? So now they're on the job, if you will, that much longer, right? Most administrators, executors, Jenna, I think you'd agree, right? They want to do their job and then get on with it and get done. It takes longer. That's less satisfying as well.
And I know we've all received those letters saying that we're the beneficiary of this estate across the world, and please give us your information. And so I could only imagine the time to to discuss the estate with these potential beneficiaries and communicate with them enough for them to trust you to give you their information, because that in itself is a big task.
Yeah.
Certainly. But I think, Jenna, you had another story that you were going to share with regards to your own complicated or estates gone badly.
Yes, it's along the same lines of improper planning or not hiring the right professionals when you are doing your planning. But years ago, I worked on an estate where we were the executor, the personal representative, and the deceased was a grandmother of lots of grandchildren. And she had a tradition that after every grandchild was born, she would update her will to add a legacy gift to that grandchild. So after each grandchild was born, she'd add a gift of 50,000 to that grandchild. And so she had all these codicils adding those gifts. She passed away after her last grandchild was born, but before she was able to do that for that last grandchild. And so what was left was all the grandchildren received their 50,000 except the last grandchild. And it was so disheartening because we knew her intention. We went to the other residual beneficiaries and we asked if they would be willing to forego a small interest in the residue of the estate to contribute the 50,000 to this last grandchild. And they said no. And so that grandchild didn't receive the funds simply because the deceased didn't retain the right kind of lawyer to do her will. If she retained someone like both of you, I'm sure you would have advised her to put in a class of beneficiaries that each grandchild alive at the time of her death would have received 50,000 and not necessarily name them individually. And so that was a really sad story that didn't have a positive outcome, but it does highlight the need to do proper planning, make sure you're getting qualified professionals in your corner, and so that you don't have to update your documents days before you pass away.
Were those grandchildren all adults, or because you talked about one being born and then she didn't update it, was that grandchild a minor or an adult? Yeah. So the other interesting issue there is you get into leaving a sum of money that has to be held in trust, and you got the complexities of the trust, and should have been a gift to maybe to a parent to give to the grandkid, because sometimes you get the cost of administration. You got that 50,000, you got to set up a trust account. Somebody has to manage it. You got to file a tax return every year. So then that 50,000 gets eaten away by these administrative costs and less money goes to the grandkids. So that sort of goes to the point of proper planning and thinking through those consequences, because oftentimes the intent is there, but they don't think through what's the process the executor is going to take to actually make this happen, right? Mm-hmm. And the administration of it. So that's where we're dealing with a qualified professional who's worked through those estates would allow maybe a better system and certainly a better description in the will. Because it's a bit awkward to say updating for every grandkid, not just do it once and put in 50 grand per grandkid. Yeah.
Yeah, absolutely. And I think too, the family dynamics change after that. It's not just who's getting the cash, but how is that family interacting with each other? I think of them quite often because it's just, what the testator wanted and maybe different than what actually happened. So yeah, lessons learned. We can all learn and improve from here on out.
Yeah, that's awkward and that kind of relates to what we talked about in story number 1 was there's a disconnect between what the legal result is and what the intention is, right? In the first example, maybe we're just speculating that wouldn't have been the person's intent, but it sounds like in your case, I think you're right to say there was no doubt what the intention was. If you're going every single time and changing the will like that, that's pretty solid that's what she wanted in that regard. Yeah. In terms of the one surviving child whose kid got cut out, like that makes it awkward in the Christmas dinners to get together and have that overhanging the family. That sometimes leads result that afterwards with estates gone badly, the family's not talking, which is a really poor result. That the family is affected negatively through poor planning. Yeah.
And speaking of being awkward, Gord, I know you have an interesting tale to tell in terms of proving AIP status. So we'd love to hear more about that.
Yeah. So AIP being adult interdependent partner, for those that are listening from the province of Alberta, that's the terminology we give to somebody who's a partner. Sometimes colloquially, we refer to that as like common law partner. CRA sometimes refer to as, you have common law status. But we have legislation that governs the relationship of two people who are not married, and that's called the Adult Interdependent Relations Act, and it sets out rules with regard to that. So interesting story. And I bring it up because actually of late, these issues have come up. There's a number of files we're dealing with right now where we have some contests about people's status as a partner or the equivalent in law of a married person. So as years ago, we had a case where dad died and there were two surviving children, so son and daughter, and they're going about in terms of administering the estate. And everything looked pretty normal. It was just an average size estate. And then suddenly afterwards, they start getting some communication from the next door neighbor. Well, the next door neighbor was a female friend. And as it turned out, long story short, apparently the female friend was a little more friendly than they understood as just being a neighbor. But as she alleged, we were together. We were doing life together. We were planning our future. And sometimes he'd be at my place and I'd be at his place. And even though they were in separate residences, neighbors back and forth, she put forward a claim that they were partners of one another. And so we got into a big debate and an argument. She hired a lawyer. We had to get there, and lots of meetings and settlement discussions and offers back and forth and communications. And obviously dealing with something that, number one, was very unsettling for them, going, Dad never told us about this. So they start from the proposition of saying, this sounds fanciful, but they're also left with, how do we say it's not true? We're not there. She doesn't sound like she's telling the truth, but how do we prove she's not telling the truth? So a very difficult situation to prove a negative, that she was not something, right? That there wasn't a relationship because he's not there to speak to it, but she's saying this is the evidence. Now, in those cases, she has the burden of proving, and thankfully cooler heads prevailed and we got it settled and said, okay, here's a sum of money. And she accepted and signed releases and off they went and were able to complete the administration of the estate. But I can tell you in terms of having the multiple meetings with them and trying to work through the settlement conversations and offers and describing risk, they could win, maybe they don't, and we got to go to court, and here's my estimate of the legal costs if we have to go to court. Very disconcerting for the son and daughter to try to wrap up dad's estate. In the context, of course, as we talk about on this podcast all the time, at the point they're grieving. Right? They just lost their dad. And now they're dealing with somebody who looks like they're trying to swoop in and grab money that should be theirs. And even on a financial perspective, it didn't even happen immediately. It came out a little bit afterwards. So I think probably in their minds, they're going, oh, this is what we're getting by way of an inheritance. And suddenly now they had to wrap their head around, we got to give away some of our money to this woman. And it's not fair. It's not right. What the heck is the law doing saying that she has any rights to this money? So very difficult when you have to get, looking at it from my perspective, you have to explain risk going, well, but here's what the law says. And she could make that claim. And we don't know if she's going to be successful, but she could be. And she can bring you through this process. And I remember at the time giving the estimates of saying, if we went all the way through and you went to have a hearing on this, right, where you both put your cases forward, there's number one, the uncertainty of that process, but then I gave them the estimate of how far in the future that was going to be. And you could just see that they were aghast at that going, what? Like it was going to extend the administration of the estate for several years before, just because of the lack of availability of court time and judges. Again, I put that in the category of estates gone badly in a situation where had he sat down, got proper advice, or been able to say, well, do I want to leave her any money, or putting some documentation together, having an agreement to say we're not partners of one another, that would have been helpful, right? But it left open the ambiguity, left open the opportunity for her to make a claim, and that forced everybody to the table. We ended up, thankfully, with a settlement, but it's all somewhat distasteful, right, for the son and daughter. So I put that in the category of estates gone badly. If there's just understanding statuses of people who are in your family, right? We talk about what's your family tree. Had he just been more definitive or entered into agreements about what's fair in the circumstances, maybe had an agreement with her saying, I'll leave you something, but I want to make sure money goes to son and daughter. Had a communication with them about, I'm going to leave her some money because, by the way, we love each other and I want to leave her some money, but I'm going to give you some. It would have been all smooth sailing, but because it came out of the blue and contentious and people are perceived a certain way, then it was all rather difficult and a very unsettling process. I'm sure if I met with them even years after and say, just started talking about it, it would bring a certain amount of angst or difficulty in terms of, what they had to go through. It would be pleasant memories with regard to that. So that is, it's just know your family tree. If there's relationships there, deal with it head on, right? And put a plan in place with that. Don't keep it a secret, because that just it's much more complication to try to resolve those matters.
We should all make our suitable agreements with our neighbors now.
Yeah, exactly. It was interesting because there's certainly rules about, well, are you cohabitating and for periods of time, and were they not? So there was some interesting legal issues that were going on in that case. But as we talk about things being black and white, there was a lot of gray, and that just led to issues in the estate administration on that.
And I suppose a lot of intimate details too about their relationship, and maybe those details the deceased didn't want his own children to know. I suspect that would be a difficult thing to hear. Thank you for that, Gord. We are going to pause here and continue our conversation on part 2 of Estates Gone Badly. So if you enjoyed the last 3 stories, please stay tuned for our next episode where we'll share 3 more of what to avoid and how to get the right professionals in your corner. Thank you very much, Michaela, and we'll see you next time when you join us for our second episode. Take care.